This is case 2022-0067, State of New Hampshire versus Odessa Lemieux.
Good morning. Attorney
Good morning.
Gordon. I understand you reserved 2 minutes.
I have.
Please
I'm
proceed.
Joshua Gordon. I represent the defendant, Odessa Lemieux, who's here in the courtroom this morning. The state had to prove in the totality of the circumstances that Odessa knowingly endangered children by purposely violating her duty of care. Odessa was not endangering children. She was trying to fix a problem with her children urinating. She had tried everything before: diet, medication, pull-ups. She'd been told it was a behavioral problem, so she tried timeouts and scheduled bathroom breaks. Odessa brought the kids to the doctor in an effort to solve the problem. That's not child endangerment. That's a troubled mother seeking solutions. And Odessa didn't violate her duty of care. She was discharging and trying to be a good mother. Perhaps not particularly effective or exemplary parenting, but not like the other cases that have been cited by the state, where kids were locked away for days or months or even years in appalling conditions. If Odessa had not gone to the doctor, we wouldn't be here. That's the action not of a criminal, but of a concerned mother. I also want to address preservation. This case presents perhaps the most terse example of a motion to dismiss, a motion for directed verdict that one can imagine. But it was enough to preserve Odessa's sufficiency arguments. This case is controlled by State versus Gordon. There, this court said in 2011, the defendant moved to dismiss the state's case on the ground that the evidence was insufficient. Nothing more was required to preserve.
So in this case, Attorney Barnes, he moved to dismiss both charges? Is that clear from the record? Or can it be said that they was just looking to dismiss the witness tampering charge on insufficiency?
He didn't specify. He just said, in fact, he didn't even say the word dismiss. The judge said, "Can I hear the motion now?" And he said, "Yes." And I cited to McNamara, where judges essentially do that all the time. McNamara's book, it's miscited. It's chapter 32. Pardon my brief. But the state admits that the defendant argued in her opening closing that she was trying to parent well, and she did. Requiring an overly specific motion for directed verdict would just create ineffective assistance counsel claims whenever a trial attorney failed to specify a hole in the state's evidence that some clever appellate attorney with the luxury of a transcript might later uncover.
But even if it's, even if that motion was enough to preserve a sufficiency claim, how does that allow this good parenting argument to go forward?
Well, she argued sufficiency, and I'm arguing sufficiency now. So those, they're two things.
But good parenting's not an element.
Good parenting isn't, but the knowingly endangering children and by purposely violating a duty of care is a sufficiency issue, so sufficiency is preserved.
So if she had the best of intentions, that's not a trump card here, is it?
Well, it's hard to imagine one having the best of intentions and doing the things that the endangerment cases have. You know, the babysitter getting drunk, or you know, the terrible cases in Maine that have been cited. Those are not good intentions. Odessa here had good intentions. She didn't knowingly endanger the children. She was trying to do exactly the opposite. And she didn't purposely violate her duty of care. She was purposely trying to discharge her duty of care. I think what happened in this case is that there was a felony tried alongside this for witness tampering, and I suspect that neither the state nor the defense counsel gave too much attention to the misdemeanor that was sort of stuck onto the back of it. And so, you know, things like the photographs were not even authenticated in any way. I'm not making that. I'm not suggesting that's an error here because it's not preserved, but those sorts of things happen. And Ted Barnes, the attorney Barnes, just said yes to the preservation solicitation by the judge. He answered yes, and that preserves the issue.
So would you agree that at some point locking a child in the room would endanger the child? You say that this doesn't, 12 hours isn't enough, but at some point that's going to be enough, isn't it?
Well, at some point, and at least the reported cases are in conjunction, the locking in the room seems almost ancillary to the other terrible things that the parent did. Is there some amount of time? Of course, you know, if the parent locks the child in the room for a year, that's going to be child endangerment.
At some point, is withholding food child endangerment?
Pardon me?
At some point, is withholding food child endangerment?
Well, of course it is, but that's not an issue here. There's several issues in the state's brief that just are not here. The trial judge specifically set aside any food problems. The state tried this at trial, and Ted Barnes objected, and the judge granted that.
So the endangerment charge is strictly based on locking the children in their bedrooms on occasion?
That's what it appears to be. The information says by tying the children in the rooms at night.
So is it your argument that the state needed to prove the specific mechanism by which the doors were locked as alleged in the complaint?
Well, I think they did. I think they had to prove that, and they did not prove it. There's no proof that the doors were tied. They may have been closed in some other fashion, but there's no proof that they were tied.
Well, didn't Ems testify that the doors were tied and she couldn't open them?
Yes, but how did she know? She was inside, so she
might have
must
tried to open
learned
them.
from something.
She might have tried to open the door. That would be some evidence that there was an impediment.
Yeah,
Right.
maybe, but there's no connection between those alleged ties or black fabric and the tie and the closing of the door. That's just
And the misdemeanor complaint was very specific. It said by tying around the doorknob and wrapped around nails. It didn't
Exactly.
just say by barricading the door.
If it said just by barricading the door, the state would not have erected their own barrier to themselves.
There was evidence of nail holes too, correct?
There was evidence of nail holes. But this was a seasonal rental. This occurred on May 28th or 29th or 30th. The seasonal rental was ending, and these people were moving out of the house to make way for the summer rentals.
And we don't know if those nail holes pre-existed their occupancy or not.
We know nothing about the nail holes other than they were there.
And your argument is that children circumvented any endangerment by urinating in their bed.
They circumvented by urinating in their bed. Yes. It's not, like I said, exemplary parenting, but it's not endangering in the way that the cases that we see where these appalling conditions are obviously endangering. This is not that. This was a mother trying to do the right thing. She tried 4 or 5 or 6 solutions, and they didn't seem to work, and she tried this one. That's not
Mr. Gordon, would you agree that even though the adequacy of the food in and of itself is not a standalone basis for this charge, that the fact that the children were told that if they left the room they would not be fed, that can be taken into account, can it be?
Well, it can't, because it's not charged conduct. It's not relevant.
Well, but if the children were told that if you have an accident in your bed, you don't get dinner, that seems to, which is what the testimony is. It seems to me that is relevant to the jury's assessment of the situation here. Whether or not food was actually withheld, if that's what they were told, that's relevant, isn't it?
I don't see how it's relevant. The charge is barricading the door with a tie. And that's the charge.
But the defense is it was part of parenting, and if the parenting, as you responded to the chief, was that they weren't endangered because they could urinate in their room, but then if that brought on this consequence, they really didn't have a choice. So doesn't that make it relevant to the restraint claim?
No, I don't think it does. If the charge is locking the door in a certain fashion, and that either constitutes endangerment or it does not. And the other things that the family did for discipline are just not part of the case.
Well, Em testified that they were locked in their rooms because sometimes they stole food at night. So why wouldn't the food deprivation be relevant then? If that was the reason why the children were being locked, because they were stealing food that they weren't entitled to, isn't that relevant?
Oh, I suppose maybe it may as a motive, but I don't think that's the reason that the children were locked in the room. You know, and I don't think that's what the state set out to prove, and I don't think that's what the evidence shows. They were locked in the room because they were urinating. That was, you know, I don't pretend to condone that as excellent parenting, but that was the testimony, and that's what the record suggests. If I see no more questions, thank you very much.
Attorney Woodcock? Thank you, Attorney Woodcock. Attorney Gordon? Okay, case is submitted. Court